only in employment law does it appear to be perfectly permissible for one party to withhold a payment that they know is owing in an effort to pressure them into a different deal.
Welcome to Water Cooler Justice. I'm Chris Robertson, and I've been practicing employment law for over 20 years, helping clients resolve disputes or navigate challenges at work.
And I'm Sarah Goodenough, Chris's law clerk.
Welcome to episode 12 of the pod. If you've been enjoying Water Cooler Justice, take a moment to follow us, leave a rating, or send your favorite episode to a friend. We appreciate the support. We've got two repeat guests joining us today, Barry Fisher and Matt Dewar. Welcome back to the pod, guys.
Thank you.
We know Barry as the Dean of Employment Law. His blog is a must-read for anyone practicing or interested in employment law. He's a mediator and arbitrator in Toronto and brings over 30 years of experience as an employment lawyer and legal author to the show today. Matt is a founding partner at Duntroon Law, as well as a professional musician. You can catch him performing around Toronto with his 80s cover band. And I also understand you hold down the St. Paddy's gig at the Wheat Sheaf every year. Yeah, I have heard nothing but great reviews.
St. Andrew's subway stop Friday afternoons. That's his specialty.
Barry.
Every little bit helps, Barry. You know
that.
Matt's an
over
active
$12 the other day.
Matt is an active mentor for many young legal professionals and frequently presents on topics such as workplace harassment, cannabis in the workplace, avoiding constructive dismissals, human rights, and employment law 101. And you may have heard him on the news sharing his perspective on employment-related matters. Thanks for joining us today, Matt and Barry.
Good to be here.
Today's episode dives into a high-stakes alleged constructive dismissal and offers a nuanced analysis on issues surrounding contractual termination provisions, various bonus structures, damages tied to incentive compensation, and when employer conduct crosses the threshold into moral and punitive liability. Sarah, can you take us through the details of the case? And I'll warn our listeners, this thing was a 5-day trial. It's long. Everything you could do right and a lot of the things you should never do wrong are in this one. So sit back and relax, and Sarah will take us through it.
Thank you, Chris. The plaintiff, George Kirchmair, is a chemical and environmental engineer and a former partner at Barenco, a boutique engineering firm specializing in environmental issues. In 2010, he joined Trow Global Holdings, now EXP Global Inc., following its acquisition of Barenco. In the transaction, plaintiff accepted shares worth $550,000 and negotiated a 3-year employment agreement that tied a significant portion of his compensation to bonuses based on EBITDA, earnings before interest, taxes, depreciation, and amortization. EBITDA is a financial indicator used to evaluate a company's core operating profitability and cash flow potential. So this essentially tied Kirchmair's bonus directly to the company's overall profitability. In 2013, an amending contract was agreed upon, which included an increased salary of $218,000 based on a 28-hour work week and introduced new bonus mechanisms linked to labor margins and contract success. At trial, EXP suggested that the intention of both parties was such that the plaintiff's employment would be short-lived thereafter, as Kirchmair had expressed some interest in setting up his own company. This never materialized, and it is the plaintiff's position that he had every intention of staying with the company long-term. Early in 2014, the relationship began to wane. Kirchmair's bonuses were delayed, in first instance by 7 months. In the years following, his bonuses were repeatedly delayed, sometimes by as much as 19 months. By the time the plaintiff's departure in August of 2017, key bonuses remained unpaid. The plaintiff claimed he had been constructively dismissed and seeks unpaid bonuses in the amount of $148,000, $382,000 representing contractual obligations pursuant to the termination provision of his employment contract, and additional moral and punitive damages of $200,000 and $100,000 respectively for what he alleged was bad faith conduct. At its core, the dispute asked whether EXP's pattern of delayed and unpaid compensation amounted to a fundamental breach of the employment relationship, transforming what appeared to be a stable long-term agreement into one that was no longer sustainable. Chris, I'll turn it over to you to explain to our audience a bit more about contractual obligations in this case.
In Ontario, a contractual obligation to pay severance set out in an employment agreement is generally enforceable so long as the provision complies with the minimum standards of the Employment Standards Act and is not otherwise somehow invalid at law. These provisions typically displace the employee's entitlement to common law reasonable notice, seeking to bind the parties to an agreed-upon severance amount. In this particular case, the employee alleged constructive dismissal, so the employee must first and foremost establish that, in fact, a constructive dismissal actually occurred. And that's one of the things we'll get into now. To succeed, the plaintiff must show that the employer breached a fundamental term of the employment contract, either by a single unilateral act or by engaging in a series of acts that were taken together, when taken together, amount to a breach of contract. So I'll start just quickly. 8 years to pay the bonus. Matt, Barry, thoughts?
I would echo Barry's comments that I too would be rather upset and grumpy if I had to wait 8 years to receive $148,000.
One might even use extraordinary measures outside the area of law to collect.
That's true. Petey Chops and Anthony Gaspipe are sent over to pay a visit.
I just spent the worst part of my job is trying to collect on unpaid invoices, and I'm like a rabid dog, and I get upset when someone hasn't paid me in 60 days. 8 years is so outrageous that it's beyond belief.
Well, so I mean, I went through the case. It's a fascinating read for those who are sort of in the biz, or if you're sort of really interested in getting deep into it. But what I thought was fascinating was this wasn't a case where the employer was saying we didn't have the ability to pay. In fact, at trial, one of the witnesses for the employer said that her best estimate of the gross revenue of the employer for fiscal 2024 was about $900 million. And she confirmed that the performance in 2017 would allow it to pay bonus. And that situation has continued to the present time. So this is not, like, it's when you're in sort of that kind of rare financial error and you're not paying the bonus, it's a choice. Right? And so I thought that was very, very interesting. The other thing I noticed was none of the witnesses could cogently explain to the court why the bonus hadn't been paid, because these were bonuses earned in some instances, right? And not bonuses during the notice period. And so I actually thought that was fascinating, right? Because I've certainly been on the eve of trial, or I've been close to the commencement of a trial where there's a bonus earned but unpaid without explanation. But I've never actually sort of crossed the line of departure into a trial where there's non-payment of wages, right? And so I'm wondering if either of you have had experience with that, or I'm wondering if you have any thoughts about that. I certainly enjoyed the roadmap that's in this case discussing the ESA provisions that prevail.
What I found interesting was that, because you're right, it's unpaid bonus is a wage issue. In fact, his termination provisions didn't apply. He got 21 months base salary. He excluded bonus from his termination provision. So because it was wages owing, to put additional pressure on the defendant, I would have named the directors personally too, which you're allowed to do under both the Ontario and the Federal Corporations Act. They didn't, I guess, because maybe at the time they thought they'd pay or something, but as I say, it's one of the most outrageous non-payment situations I've ever seen.
It's ridiculous. It's funny because the real bad guys didn't even bother showing up to trial, right? I mean,
right.
And probably you can just imagine the instructions, to the witnesses who did show up. Say anything except that we're refusing to pay because we wanted to, put a metaphorical gun to his head to sign the new agreement. We say anything, we just don't care, kind of thing. It's very telling, and the judge clearly is a big fan of the employer, as you can tell.
Well, I think that's an important fact too, Matt, right? The fact that the non-payment is timed with efforts to renegotiate the compensation scheme, right? To change the structure of the incentive or the bonus compensation. And I think that's a big flag for employers. I think it's something that should be avoided if it can be avoided. And the other thing that I think is really specific to this particular case is, I believe this was a compensation scheme of one, right? That this particular employee had been retained as part of a transaction and had negotiated a very specific incentive compensation scheme. And he was the only one perhaps under that plan. It probably makes the non-payment worse, not better. But, if I was acting for an employer, If I was trying to renegotiate a compensation scheme, you'd certainly want to see that renegotiation apply to everyone under the scheme and not just one individual or one employee, because that would be exceptionally difficult to explain at trial as well.
And the other thing too is this bonus scheme, unlike many that I see, was completely objective. It was numbers based. There was no subjective component. There was
Right.
nothing the employer could play around with. This guy wasn't stupid. Obviously, he had a lot of negotiating power, so he specifically negotiated a monetary payment, and still they didn't pay.
Right. And earned it, right? Because if it's if it's a strictly formulaic payment based on performance or revenue or EBITDA or whatever the particular metric was, in order to earn the bonus, right, the results had to flow.
Exactly. And I see a lot of cases like this, and I don't understand the thinking behind it, but where the sales guy does his job. The deal is the deal. Here's if you do X, you get Y. If you do, and then he knocks it out of the park, and Y is equal to more money than the president makes or something. And then the president gets bent out of shape and is angry over the fact that, but if you follow that through, you're like, well, yeah, but if he's getting Y, that must mean the company made a whole ton of money. Pay him. Just pay him. Do the right thing. And Barry, I'm going to invoke you, as I often do, again, which is just treat the employee fairly. Give them a fair shake. Don't try and be ridiculous. Don't try and nickel and dime them down. Certainly don't do what our friends over there at EXP did. And you'll probably be okay. I mean, you might have to pay a little bit more money, but you're not going to get hammered the way that these guys did. Treat an employee decently.
And it's not unusual. And when I blogged about it, the headline was the moral damages, as the judge called them, were equal to the amount of the unpaid debt. Basically, he didn't pull that 150 just out of the air. That's basically what was owed.
Yeah.
Right. Well, so I mean, I think maybe that's a great, let's move on to that, because I think that's the heart of this case for me. So maybe I'll let Sarah just sort of read our listeners into what actually happened.
The plaintiff claimed significant amounts in both moral and punitive damages. So for a quick refresher on damages, you can check out episode 6, where we discuss Galea versus Walmart. In this case, the trial judge initially awarded Galea $250,000 for moral damages and $500,000 for punitive damages, among the largest amounts seen in the Ontario Employment Bar. On appeal, these amounts were ultimately reduced, but the case remains to be a significant case and is cited frequently. Do we think the actions taken by EXP met the legal test to warrant awards for moral and or punitive damages in this case?
Well, in Galea, as I recall, it's been a while, the judge was very upset because Walmart didn't fire Galea early enough. They strung her, I think it was a her, right? It was a female. They strung her along for 8 or 9 months and then fired her. I always thought that was odd because the judge criticized Walmart for employing this person for longer than they should have. I always found that odd. So I don't know what's worse, employing someone longer than you should have or not paying someone for their bonus. To me, that's an easy one. The non-payment of bonus over this extended period of time, to me, is outrageous. I've never quite understood Galea. Why Galea was so horribly treated by being misled about her continued employment. But anyways, I'm not the Court of Appeal, so.
Well, it's interesting. Matt, thoughts?
Yeah, well, I mean, I might sort of underscore what I said earlier, which is it's clear that the judge was none too pleased. I mean, was really, really upset with this idea of, I mean, they were jerking him around deliberately, mildly by not responding to emails, just sort of ghosting him for a little bit. And then all of that sort of behavior, but even at trial, not calling the witnesses that they should have called. I mean, he's not happy about this. He's dismissing people's testimony as utterly uncredible. They just did everything wrong. And so if you want to, if you want to get punished like that, you bait the judge. You treat the employee poorly, and then you act stupid in court. I mean, stupid is as stupid as does, and they got whacked for it, big time.
Yeah, and this was a constructive dismissal matter, right? They needed to keep this guy post-transaction. They entered into an agreement, and then when they, didn't need him, they began to try and renegotiate his compensation structure. They withheld payment to try and force that negotiation. There was some reduction in his work week. He was supposed to be 28 hours a week, but he says he was working around the clock. Hint, hint, there are no such things as lifestyle jobs for those of you who are getting those offers, right? If it looks too good to be true, it might be. But the delayed payment on the bonus was problematic. Constructive dismissal claims always have a whiff of bad faith to begin with. So I do wonder, the notice period was, as Barry pointed out rightly, a liquidated damages case, right? So there was no mitigation and the number was set. The bonus, the judge awarded the number which the plaintiff themselves calculated, right? So when I look at, is there a need for damages here, right? What's the additional behavior here that isn't going to be compensated or offset by costs, right? And for me, it's the breach of the ESA. For me, it's that, you just didn't even play by the rules, the base rules. Like if the ESA are minimum standards by which employers and employees, must operate, for me, that seems to be where the judge really, really took some time, right? He roadmapped out why the incentive payments were wages for the purposes of the Act. He roadmapped out that neither party has the right to contract out of the Act. He roadmapped out the provision within the ESA which requires timely payment. And for me, I think that tells me a lot, right? If you have a bonus plan, or if you're participating in a bonus plan and you expect to be paid under that plan and you're not at the same time that everyone else is, I think that this case is an important case and one that you want to be aware of. Now, $150,000, which is the bonus amount, I have some questions about. How do I advise my plaintiff clients who haven't been paid their bonus on time what the possible moral or punitive damage award, I guess moral or aggravated damage award in this instance, might be? Because I don't think that if you had this trial 10 times, you get $150,000 10 times, right? I think that there's some room for discretion. And so I wonder, right, like $150,000 is material to this particular settlement, right? I wonder, though, if this is going to lead to plaintiffs who want to go the distance, who want to go to trial, because they see the potential for this recovery themselves, basically one times bonus amount, right? And is this going to lead to more trials? Is this is the aspect that the employer conduct that we're trying to sort of address, is the solution creating more problems? Thoughts?
I think this is extraordinary circumstances. I mean, you got to look at the facts. I mean, 8 years is unheard of until now, I suppose. And so,
without explanation at trial,
without
yeah.
explanation. I think that, under the circumstances, if you've got a client that had to wait 8 years to get payment, then yeah, why wouldn't you go in hot? But I think it's going to be fairly fact specific. I mean, if they're withholding the bonus, if they don't have the money, if it was an honest mistake, if they've entered into a payment plan, to whatever. I mean, there's all sorts of kind of mitigating facts that I can imagine. Related, though, I wonder, it's almost, had he filed an ESA claim and added in a reprisal complaint about it, right? Pay me my wages, and then they basically fire him, right? I wonder what the ministry, I know the timelines won't work out because they've got more power today than they did way back then. But I wonder if the ministry would have hammered them with $150,000. I don't know.
No, the Act wouldn't allow them to do so.
No,
there's no punitive damages under the Act.
Well, it's reprisal, though, right? I mean, you can
reprisal damages, yeah. Okay.
Yeah, that's what I mean. Sort of. Anyway,
I find it more. I look at this case a little broader. This was a situation where clearly the employer owed the money, and they withheld the amount, right? Okay, but we all encounter cases every day where, let's say, the dismissed employee is clearly entitled to north of 12 months notice. Whether it's 12 or 18, somebody argue, but everybody knows it's going to be at least 12. Many employers, I would argue most employers, pay the ESA only and will not pay anything more unless there's a settlement. Well, isn't that similar to this? Why should one party, if I think I owe the bank $100 and the bank thinks I owe them $110, do I get away paying the bank nothing? No. I pay what I think is owing, and if they want to litigate over the balance. Only in employment law does it appear to be perfectly permissible for one party to withhold a payment that they know is owing in an effort to pressure them into a different deal. The original Wallace case, way back in the olden days.
Wow.
I think this is before Matt had a beard, which was about age 5, I think, in his case.
Is that the acetone copy you've got there, Barry?
Yes. In Wallace damages.
For the listeners who can't see it at home, Matt just held the parchment as it crumbled in his hands.
Blew the dust off of it.
In the Wallace and United Grain Growers case, which is really moral damages, mental distress, we called it Wallace damages for a while. Anyways, one of the criteria for Wallace damages was hardball tactics by the employer. Well, if not paying someone a bonus that's owing to them is a hardball tactic, why isn't, I know the guy's entitled to at least X notice, why am I allowed not to pay him what I think the right amount is? Why can I withhold everything until the court decides? So I'm wondering whether anybody will use that argument.
I think that's exactly it. I will, right? Because that's what I think the judge is actually saying. That this non-discretionary bonus was required to be paid under the Act, right? If you thought that you had liability for any wages, you know that the minimum is the ESA. You know that you've got to pay this particular bonus because it's a wage under the ESA. Pay it. Now, in defense to EXP, they did, I believe, allege cause. It's not clear to me whether the allegations of cause were maintained all the way to trial, but there definitely were some allegations of misconduct in the run-up to trial, I think is fair to say. So, I mean, I can understand perhaps why they might not have paid anything, except that it's a constructive dismissal case. I don't think I've seen a lot of cases where both constructive dismissal and cause are alleged simultaneously.
And even if he was fired for cause, that may deny him his right to severance, but how does it deny him his right to wages earned?
Wages earned but unpaid, correct.
Right.
Yeah, so. Right? I think that's why the judge is, I think this is actually a really technical case. And I think sometimes that real technical analysis gets lost in the overarching discussions and what we take from a surface read. But I think that's what really underlies this, is that in this particular dispute, there was a real technical issue. The bonus was owed and it wasn't paid. And it's not clear to me that the employer party really understood that. And to the extent that they did understand it, it appears that once they became aware of it, they took steps to not do anything about it. And, last thing I'll say is that the people who were in a position to really, really know at the employer did not show up. They did not appear as witnesses. And I think that was unfortunate for this particular outcome.
They didn't, as I kind of alluded to earlier too. I mean, you just know they knew they were going to get killed. We're not going. You go. You be the fall guy. Just don't admit, just claim that you don't know anything. I'm going to stay in Chicago or wherever the guys are located. I mean, they did everything wrong. It's simple as that. They did everything wrong.
Yeah, well...
If they all did it right, we'd all be out of business.
That's true.
Well, and, this is ultimately the purpose of courts, right? Like if the parties can't agree on, something as simple as the basic facts, or they can't agree on something as simple as the basic entitlements, that's what the courts are for.
Well, but we don't know that. I mean, this case, is it a Toronto action? It would have gone to mediation. It'll be interesting to see, maybe we'll never will, whether there were real offers. Sometimes on the surface, it looks like the defendant was a real jerk and the plaintiff won. And then when you dig in, you find the plaintiff's offers were so ridiculous, no defendant could have accepted them anyways. I don't know the story behind this one. Maybe we never will, because I haven't seen a cost award. But sometimes behind the scenes, the defendant made serious, meaningful offers and the plaintiff said no, and the plaintiff wins. I don't think in this case that happened, but you can't always tell from the surface.
It's hard. Go ahead, Matt.
Oh, sorry, I was just going to say it's kind of hilarious too that the court's busy haranguing the defendant for not producing what they should have produced and paying what they should have paid, and the court did the same thing with the decision, right? Wasn't it?
Yes, that was the ultimate irony of it. Yes.
Right.
Apparently, the court clerk, the judge issued his decision a year ago, and the court clerk sat on it. Because when I found this case, and then I read it, and I called up the lawyer, and I said, we just found out 2 days ago. What are you talking about? The court forgot to send out the case for a year. For a year, which is kind of bizarre because normally when I was a lawyer and the judge took too long, I'd phone the court a couple times saying, hey, what's happening? But apparently, out of the blue, it came literally a year later. So I wonder if they got stuck with the PJI, well, with the prejudgment interest. Yeah, that's just sort of an added screw up here that even the court couldn't get the judgment out. But it's remarkable that Mr. What's his face, Mr. Kirchmair was so patient. He never asked his lawyer, like, what's happening? Like, a lot of lawyers are reluctant to write to the court, though. They think, oh, if I bug the judge, I'm going to lose. No, you just got a dumb clerk there who never bothered sending it out.
Well, when you've waited 8 years, Barry, what's one more year, right?
Yeah, what's one more year at prejudgment interest of 3% or something, whatever it was.
Right. So, I'm glad you raised that, Barry, because I think that's another part of another function of the problem, right? Is that if you want to hang on to the money, if you want to be difficult, if you're prepared to pay higher costs, if you're prepared to lose a trial, right, to make a point as a matter of principle, whatever, the employer with the larger wallet and the greater financial means than the unemployed employee, there isn't really a big disincentive mechanism through Courts of Justice Act interest. And I also think that Courts of Justice Act interest rarely reflects the actual borrowing cost for people who may be borrowing from their lines of credit or maybe borrowing from other...
No, it's the Bank of Canada rate. It's the lowest.
Right. It's the lowest rate. So
I don't know what credit card you have. I don't know what credit card you have, but mine charges me more than 3% if I were to have a balance. No, it's definitely with low PJI rates, there's some incentive for an employer, but not in the real world, not by paying their lawyers and stuff like that. It still doesn't make sense.
Right. 5-day trial too, right? So this is the cost award is going to be exorbitant.
Huge.
Right. So if it's 5 days to prepare, 5 days for trial, plus all of the...
Yeah, I did follow up with I doubt the cost. I haven't seen a cost award yet. So they may have resolved it between themselves. Yeah. Maybe the defendant was finally embarrassed enough to settle. I don't know.
Yeah. Well, and the last thing I'll say, to your point about offers exchanged, again, this was an unusual case, constructive dismissal versus cause with liquidated damages. So you're either entitled to the whole thing or you're entitled to nothing. Right. So I could see how this matter might have made its way to trial. I'm just surprised given the high dollar value and at some of the tactics, right? The bonus earned but unpaid was earned prior to the termination date, right? Or prior to the cause date, presumably. And so really hard to understand the non-payment. And I think that's the big takeaway here, at least for me. And I also think if I had known that this thing was going to go for 5 days, I might have actually gone up just to listen to the closing submissions. I think it would have been this would have been a fascinating case to listen to the submissions just because of the complexity of the facts and some of the claims that were made. Any last thoughts, guys?
Once again, just do the right thing. Do the right thing. Don't.
That was a really good movie.
Yeah.
Or what is the other one? Why can't we all get along? Was that not George Floyd, the other guy?
Rodney King.
Why can't we all?
Good goodness. Yeah. Look, the courts exist for a reason to settle disputes that unfortunately cannot be settled at mediation. Barry, as always, a quick plug for you. Mediation works. Again, though, on this particular file, on this particular set of facts, I can understand why the parties may have ended up at trial. What I don't understand is the non-payment of wages earned, and what I wonder about are if the damages are going to be that high for that particular breach, right? Is that the new metric? If you were supposed to pay $20,000 under the ESA and you failed to do so, is the damages award $20,000? If you were supposed to pay $400,000 under the ESA, does that make the damage award $400,000? Because that doesn't seem to be super consistent with the ideas that we got in Honda v. Keys and some of the other case law that followed that decision, right? Thank you guys for coming on again. A super fun chat. We love stories of workplace drama. If you want to share yours, reach out to us through our links on Spotify. Email us at watercoolerjustice, all one word, @gmail.com. Until the next time,